you're here?
I am peacefully assembling and peacefully protesting.
Okay.
There's a provision in there that says it shall not infringe on a person's right to peacefully assemble and protest. If you look at the statute, it's right there in the statute. So that's why I'm here.
This is within the 500-foot safety rule, so I'm placing you under arrest for violation of that no trespass order. If you would, put your sign down, turn your phone off, put your hands behind your back, please.
You guys, I'm just telling you, if you look at the statute, in the statute it specifically says there's an exception for people peacefully assembling and protesting.
Is that if they don't have a trespass warning for the property?
On March 14th, 2016, I was falsely arrested by Sergeant Jay Lawing and Sergeant Jim Priester of the St. Johns County Sheriff's Department while peaceably assembling and peaceably protesting on a public sidewalk. I was falsely charged with violating a bogus school safety zone trespass warning issued against me by the St. Johns County School Board. Despite the fact that Florida's unconstitutional school safety zone statute clearly carves out a specific exemption for people who are peaceably assembling and peaceably protesting. Benjamin J. Rich, Assistant State Attorney of the State Attorney's Office for the 7th Judicial Circuit of Florida, refused to prosecute me and dropped all false charges. This makes the 5th time since 2012 that I have been falsely arrested, with all charges being dropped before trial. Assistant State Attorney Ben Rich had this to say about his decision not to prosecute. The sidewalk where Mr. Gray is alleged to have trespassed is not St. Johns County School Board property. The sidewalk is a public sidewalk and within the 60-foot right-of-way. However, where Mr. Gray was standing at the time of the arrest was approximately 40 feet from the front doors of St. Augustine High School. Mr. Gray was well within the 500-foot school safety zone as defined by Florida Statute 810.0975. Florida Statute 810.0975 does have a negative history. In Gray v. Cole, a U.S. District Court in Southern Florida found provisions of 810.0975 unconstitutionally vague as to violate due process. Specifically, the court held that subsections 2A and 2B of 810.0975 Florida statutes are declared unconstitutionally vague and permanently enjoin the state of Florida and its officers from enforcing those subsections. It should be noted that Gray v. Cole is not controlling, but is persuasive in authority. Furthermore, review of the legislative history of 810.0975 gives insight concerning the intent of the statute. It was the legislature's intent in the construction of this law to protect children by creating a 500-foot buffer zone around all schools so that persons such as drug dealers, gang members, or pedophiles can be kept a safe distance from children while arriving to, attending, or leaving school. In the case at hand, there is no evidence that would lead one to a reasonable suspicion that Mr. Gray was engaged in any of the conduct sought to be prohibited by 810.0975. In 2013, 810.0975 was amended, adding subsections 3 and 4 were made to 810.0975. The addition of those subsections was to ensure that the First Amendment rights of Florida citizens would not be infringed upon by the enactment and enforcement of 810.0975. Pertinent to this case is subsection 3, which permits peaceful protests within the school safety zone. In conclusion, there is no evidence that at any point during the March 14, 2016 incident, Mr. Gray entered or remained on St. Johns County School Board property after having been warned not to trespass. Therefore, 810.09, trespass in structure or conveyance, and 810.08, trespass on property other than structure or conveyance, do not apply, as Mr. Gray did not enter onto the premises of St. Augustine High School or any of its structures. Second, at the time of his arrest, Mr. Gray was standing on a public sidewalk within a school safety zone holding a sign in protest. There is no evidence or testimony that could lead a person to a reasonable belief that Mr. Gray was preparing to commit a crime or was engaged in harassing students, and therefore 810.0975, Parent C, 1, does not apply. There is no testimony or evidence that Mr. Gray's conduct disrupted or disturbed any of the students of St. Augustine High School on March 14, 2016. After considering all of the evidence and testimony concerning the particular incident, given the totality of circumstances in this case, the evidence does not meet the standards established for criminal prosecution. Benjamin J. Rich, Assistant State Attorney. In St. Johns County, Florida, there are hundreds of registered sex offenders, as well as hundreds of drug dealers and dozens of known gang members. Within a 5-mile radius of the address where I was arrested at St. Augustine High School, there are 116 registered sex offenders alone. Through a public records request, I have discovered that the St. Johns County School Board has never enforced a school safety zone statute against a single pedophile, drug dealer, or gang member. In fact, the only person the St. Johns County School Board has ever enforced a school safety zone statute against is Jeff Gray, a concerned parent and open government advocate.